The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several locations for your convenience. Thank you so much for watching and listening.
Hi, this is Andrew with Learn About Law, and in today's video we'll cover implied agreements as the basis of a probate claim in Illinois. We'll discuss what an implied agreement is versus an explicit or contractual agreement, some factors the courts look at when determining the validity of an implied agreement, how whether the caregiver is related to the decedent affects the claim, and what evidence is needed to overcome a presumption of gratuity. So claims based on implied agreements have long been a thorn in the side of quick, painless litigation. Trying to prove that an agreement exists between two or more parties without a written contract can be difficult, especially in the case of a probate claim when one member of the agreement has died. Generally, when terms are agreed upon, written down, and signed, the agreement becomes an explicit contract. Also, in the absence of a document stating the specific terms, if it can be proven the two parties discussed the terms and came to an agreement, the argument can still be made for an implied contract or explicit agreement. Typically, the terms, conditions, and ultimately the validity of an implied agreement will be confirmed by the actions of the parties involved. A simple example of an implied agreement might be you speak with a friend or an acquaintance at length who is a home decorator. He or she suggests a number of improvements to your home and even drafts up a simple design blueprint. Under implied by law, even though you didn't explicitly discuss payment of the services rendered by the decorator, you could still receive a bill and be required by law to pay. Some of the factors the courts consider when determining the validity of an implied agreement are going to include things like the kin or family relationship between the parties. So if the parties involved are unrelated, and normally the courts are going to be looking at things like first and second degrees of relation, such as a spouse, sibling, parent, child, niece, first cousin, etc. Again, then it's going to be more likely that the court will favor an implied agreement. If the receiving party asks for the services or made no attempt to deny the services. So this point seems straightforward, and the court would normally favor the implied agreement here. But in the case of the receiving party being physically incapacitated and unable to make decisions for themselves, the court would look at the role of the guardian if they were not also the caretaker. Next, we've got frequency and scope of care. So how often the care was done, daily, weekly, etc., and no real discernible frequency. And what was done will be evaluated when determining the validity of an implied agreement of care. Many probate claims dealing with an implied agreement for care involve two or more parties with an existing relationship, usually a relative. The timetable for the establishment of the implied agreement is often disputable, and the scope of care frequently changes over time. A case can be further complicated if the parties involved were sharing the same dwelling and or sharing living expenses. In Illinois, the courts more easily support an implied agreement claim when the parties are unrelated, and often services by family members are generally presumed to be rendered without expectation of payment. I'll quickly discuss some examples of implied agreement claims in Illinois and their rulings to give you some examples, right? So two nieces provided care for an aunt who lived with one of the nieces. Upon the death of the aunt, the nieces both filed implied agreement claims against the aunt's estate for compensation. Initially, because of the relationship between the parties, the case was dismissed. But after moving to the appellate court, it was determined that the nieces were to be compensated based on the testimony of third parties stating the aunt wanted the nieces to be compensated. Another example found in a case involving a near familial relationship, the claimant lived in some capacity with the decedent for over 20 years, providing services such as carpentry, upholstery, etc., and in the decedent's time of illness, some form of caregiving. When examining the two parties' relationship further, it was found they often celebrated birthday parties together, exchanged gifts, and the claimant went to many of the decedent's family members' funerals. The court found that the claimant and the decedent shared a near familial relationship and viewed the care as gratuitous. Once the assumption of gratuity is raised, it becomes the claimant's responsibility then to prove otherwise. Lastly, let's talk about overcoming the presumption of gratuity. So an expressed or implied contract will typically be enough to easily overcome the presumption of gratuity in the eyes of the court. Some other factors relevant in reversing the presumption of gratuity are going to include the circumstances under which the claimant first began providing services to the decedent, the decedent's failure to reciprocate through money or exchange of services in any kind, the effect of the claimant's services on the decedent's estate, the degree of services rendered by the claimant, specifically if they go far beyond what is normal for a domestic relationship, the financial situation of the parties involved, and any language in the decedent's trust or will involving the claimant. So in summary, the important lesson to learn from this video is that if you find yourself suddenly taking on caregiving duties, even for a family member, and you're concerned about appropriate restitution now or in the future, it is best to have, at the very least, a simple contract written up and signed by all parties involved. Thanks for tuning in.
Hi, Kevin O'Flaherty again from O'Flaherty Law. Hope you enjoyed our presentation of Learn About Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.